Welcome. I am the loud little ducky. Today is the day that everybody in the Owens v. Echard case has been waiting for. We have a ruling from the trial or the court hearing from Monday, June 10th, 2024. The judge took it under advisement and she has now issued her rulings. So let's jump in and see what the Honorable Judge Mata finds. So here we have in the Superior Court of Arizona, Maricopa County, from the Honorable Judge Mata on 6/18/2024. This was filed, and it is Laura Owens and her attorney Gingras, and Clayton Echard with his attorneys Woodnick and Deandra Arena, who I have to say, for her, when she cross-examines somebody, she makes it her arena. It is Deandra's arena on cross-examination if you are facing her. But besides that, this was an under advisement ruling, an in-person evidentiary hearing, which is why I tried to call it a court hearing or a hearing as opposed to a trial, because it wasn't a trial. They hadn't gotten that far into it being a trial, which is part of the reason it was only allotted for 2 hours. If it was trial, it would be completely different. But it was held on June 10, 2024, regarding the issues of sanctions, paternity, attorney's fees, and cost. Jurisdictional findings. The court finds at the time this action was commenced, at least one of the parties was domiciled in the state of Arizona, and that said domicile had been maintained for at least 90 days prior to filing the petition. There are no minor children common to the parties. Yep, no children between the two of them. When they say that, they're talking about living children. But, so you got to make sure, okay, somebody has lived in Arizona at least for 90 days prior to this petition even being filed. They have found that that is true. So, procedural history. This is going to be through Judge Mata's view of everything that has kind of happened. The first one says, Laura Owens, petitioner, filed a pro per petition to establish paternity, legal decision-making, parenting time, and child support on May 20th, 2023, which that is an error. It needs to say August 1st of 2023. May 20th, 2023 is the date that them two apparently had their sexual activities. So May 20th is probably just ingrained in her brain, unfortunately. So that's a mistake, which that can be fixed. I don't think that's going to make a difference on anything that happens here, but it says petitioner filed a pro per motion to communicate on August 23rd, 2023, a motion to compel on August 29th, 2023, and an expedited consideration request, motion to communicate filed September 14th, 2023, an expedited motion to seal court record on September 14th, 2023. All motions were denied. Clayton Echard, respondent, filed a pro per answer on August 21st, 2023. The court granted respondent's motion for leave to amend response filed by counsel on December 12th, 2023, and amended response to petition to establish filed on January 26, 2024. The parties attended an early resolution conference on September 28, 2023, wherein the parties entered into a Rule 69 agreement to comply with a Ravgen DNA test on October 2nd, 2023. On October 6, 2023, petitioner filed an ex parte order of protection. in the Owens v. Echard, the one that was sought, the case that was sought by Judge Duty. I'm trying to see, Rule 69, Arizona family law. Settle their disputes privately, leave only unresolved issues to be resolved by family law. Okay. So that just means that Rule 69 just means that you try to come to an agreement and then get the judge to rule on whatever y'all still don't agree to, which was pretty much everything. So they were going to comply with the Rabgen test. On October 6th, petitioner filed an order of protection. After a hearing, the order of protection was affirmed. The same day, the Rabgen results indicated little to no fetal DNA. On October 18, 2023, petitioner filed a request for pre-decree mediation, citing acts as if the unborn children don't exist despite a preponderance of the evidence, which just means there's a grammatical error. Like, that's not how that actually is supposed to be said or used. It's used wrong. It's not a preponderance. It's not a preponderance, okay? That's not what this is at all. And she cites the docket and stuff like that. On October 24th, 2023, the parties appeared before Commissioner G, retired. So Commissioner, or Judge G, as we've called her, because her name is hard to pronounce, she is retired. She said, peace out. I've seen it all now. I don't need to deal with any more of this. I'm done with the bench if this is what people are going to be bringing to me. No, that's probably not why she retired, but can you imagine? In response to the injunction against harassment, the IAH filed by respondent Clayton Echard, on the parties stipulated, the court previously reviewed both days of the hearing and identified that the petitioner, appearing virtually, frequently stood up. No, she didn't frequently stand up. She stood the entire time and rubbed what appeared to be a swollen abdomen. And I love that the judge is using swollen abdomen, because that's what they were calling it. That's what Gingras and Owens were stating it was a swollen abdomen. You know, we call it the fake moon belly bump. But pregnant people do not say, oh, my abdomen is so swollen today. Look how swollen my abdomen is. My abdomen is 8 months swollen. No, but she's using this. She's not using what appears to be a pregnant belly. She just says swollen abdomen. She's using the words that Owens and Gingras used themselves, which has been weird this entire time since it's been brought up. November 2nd, 2023. Testimony resumed, and petitioner testified that she was 100% and 24 weeks pregnant with respondent's children. She further testified that the twins were due on February 14th, 2024. Little V-Day babies. She further testified that due to epilepsy, she was experiencing a high-risk pregnancy and was being cared for by two specialists named Dr. McCool and Dr. Higley. She testified she last saw, that should emphasis added on saw, Dr. Higley last Friday, prior to the November 2nd, 2023 hearing. Yeah, and as we kept saying, well, if you saw him, he would have told you whether the babies were okay or not. Another reason we knew she didn't go see anybody, because she would have had an update on heartbeats and if it was still viable and there'd be sonogram images and all that. But we knew she was lying. She couldn't produce any evidence of it. On October 25th, 2023, the parties appeared before Commissioner Duty to determine the validity of the contested order of protection in that case. Petitioner's abdomen again appeared to be swollen. During this hearing, she testified to the validity of the sonogram sent to the respondent, the media, and a Dropbox on Reddit, and further testified the parties were having a son. She later testified she believed she was having fraternal twins, one boy, one girl, which we still have no proof of who told her that and where that information came from, because nobody told her that. Little demons in her head told her that. On December 6, 2023, a second RavGen test confirmed little to no fetal DNA. So we have 2 little to no fetal DNAs. A third test was done, however, test results were lost in transit. December 12, 2023, respondent filed a notice of filing an affidavit of non-paternity. December 28, 2023, petitioner filed a motion to dismiss petition to establish paternity, legal decision-making, parenting time, and child support with prejudice in conjunction with a notice requiring strict compliance with Arizona rules of evidence, thereby invoking Arizona Rules of Family Law Procedure, Rule 2A. Petitioner cited the basis for the dismissal that she is not now pregnant with respondent's children, cites the docket. The motion was denied as the issue of attorney's fees, costs, and sanctions remain. January 2nd, 2024, petitioner filed an expedited motion to quash deposition of petitioner. Yeah, she didn't want to go to her deposition. January 3rd, 2024, respondent filed a response/objection to the petitioner's motion to dismiss. The court denied petitioner's motion to quash. Respondent withdrew his motion for sanctions pursuant to Rule 26 on January 3rd, 2024. Petitioner filed a motion for confidentiality and preliminary protective order on January 18th, 2024, which then Gingrich comes aboard and just pretends that that ruling doesn't exist. Respondents participated in a deposition on February 2nd, 2024. At a status conference on February 21st, 2024, petitioner was ordered by this court to comply with Rule 49 disclosure requirements. During the hearing, petitioner's counsel advised the petitioner had miscarried sometime in September or October 2023. So February 2nd is when Clayton had his deposition, and then petitioner Laura Owens had her deposition on March 1st, 2024. Laura Owens couldn't attend her own deposition, but the first one, but she could attend Clayton's on the 2nd of February, and then she eventually went to her one on March 1st, even though she didn't want to. On June 3rd, 2024, petitioner's prior counsel filed Ethical Rule 3.3 Notice of Candor, wherein counsel advises the court that statements made by counsel at February 21st, 2024 status conference were factually incorrect. Specifically, counsel stated Ms. Owens has not lied in this case. She has not intentionally lied to the court. While counsel believed the statements to be accurate at the time, counsel later determined those statements were not true based on the petitioner's deposition taken March 1st, 2024. Voluminous additional pretrial pleadings were filed by both parties. Those motions were ruled on separately by minute entry, and the rulings are not relevant for the purposes of this hearing. Petitioner contacted respondent through LinkedIn. These are findings of facts. So these are things that are We're stating 4 facts right now. Some of them are kind of funny. Petitioner contacted respondent through LinkedIn. Okay, we know that. Petitioner and respondent met on May 17th to locate potential investment properties in Scottsdale. Petitioner has a podcast, a real estate investment company, and buys and sells horses. Remember, she is an avid horse lover. Her family and her own a horse business. She is in many horse riding competitions. Horses are her life, along with senior dogs. There is nothing bad about those. Those are some redeeming qualities. But horses may take a huge role in this case. Did she misuse horse stuff? Between May 18th through the 20th, the parties viewed some properties in Scottsdale. On the evening of May 20th, respondent Clayton invited petitioner Owens over to his house, which she accepted. After Owens arrived, Echard told her he was high on cannabis gummies, and he offered one to her, which she accepted. So they're both on the cannabis gummies. During the late evening of May 20th, 2023, and the early morning of May 21st, both parties agreed that petitioner performed oral sex on respondent to completion twice. Petitioner testified she did not want to have intercourse, but that respondent stuck it in briefly. Petitioner implicated that respondent initiated intercourse without consent. Was not alleged initially in the court filings. It was not alleged until 2024. I'm glad she took notice of this because it wasn't brought in. And that would be one thing that I would absolutely bring in my order of protection hearing in front of Judge Duty. And that would have nothing to do with whether I was pregnant or not pregnant, or there was a Halloween costume with a sonogram on it. You would have gotten it for that. But you didn't mention any of that when you were oh so scared of Clayton hurting you and your unborn fictitious twins. Fellatio twins. At trial, petitioner testified that the parties had intercourse and that it was ARPing. Petitioner testified respondent was too high to remember intercourse due to his involuntary intoxication. Or his voluntary, not involuntary. Okay, but why were you not? You had a gummy too. So why aren't you intoxicated? Why are you not the one that's so high that you can't remember? Like, shouldn't it work both ways? Petitioner believes she became pregnant on May 20th, 2023. She testified that after May 20th, 2023, her menstrual period stopped and did not resume until November 2023. Petitioner has had PCOS since the age of 17 and does not have regular periods. Petitioner has a history of epilepsy. Petitioner testified she has been pregnant 4 times. Yep, we're up to 4. It was 2 and then 3 and then 4, and the number just keeps getting bigger. Each time, the alleged father believed she fabricated the pregnancy and doctored medical records. Matt, Mr. Gregory Gillespie, and Mr. Michael Maricini. So the judge isn't set to rule on anything with their interactions with Owens. She didn't even get to hear from them in this, really. But she's seen the things and she's saying, I see you, that this is a pattern. Like, I recognize that y'all's stories are similar to Clayton's. And I hope that Greg and Matt and Michael are like, thank you. At least somebody sees me. And it may not change anything in their lives as far as in the courts. I hope that they get justice in their own. But at least there's a judge out there that is saying that she recognizes that there is a pattern of fabricated pregnancy and doctored medical records. She's noticing them, and I hope that makes them feel a little bit better. On May 24th, 2023, petitioner asked respondent to prepare written purchase offers, my gosh, for 2 properties. Petitioner wanted to purchase in Scottsdale, and then it tells the location. One of the offer amounts was $425,000, and the other offer amount was $699,000. More findings of facts. Petitioner asked respondent as her realtor to prepare these purchase offers and then submit them to the seller or the seller's agent. Respondent prepared the purchase offer, which petitioner signed on or around May 24th, 2023, but respondent never submitted them to the seller or the seller's agent. Petitioner later asked respondent if he had heard anything from the seller in his response to Laura's offers. Respondent advised he had not heard back from the seller. Okay. I was just seeing if it was something else, but no. I mean, it wasn't ever submitted, not by Clayton. Okay. Respondent advised he had not heard back from the seller. Petitioner testified that she advised the real estate board and actions were taken. On May 31st, 2023, petitioner took a home pregnancy test, which showed a faint positive result. Petitioner testified that after multiple positive pregnancy tests, she told the respondent she was pregnant. Petitioner denies using hormones, someone else's urine, or altering the test at all. Petitioner found respondent's reaction to be hostile and dismissive. Yeah, because if they don't say, you know what, I love you, I want to marry you, like, we're going to be together and make this work, they're automatically hostile and dismissive. But Owens would never be hostile and dismissive, you know. Like, she is always calm as a cucumber, no extra drama with her. Obviously, that is satire, as Gingras would say. On June 1st, 2023, petitioner went to Banner Urgent Care. She informed the nurse that she believed she may be pregnant, and she asked for a test to determine whether she was, in fact, pregnant. The test result from Banner Urgent Care was positive for pregnancy. Thank you, Better Health Patient Portal. Your patient portal is the patient portal of all patient portals. Petitioner testified that for more than 6 months prior to May 2023, she was not sexually active with any other men. Based on this, petitioner testified that she believed she was pregnant and respondent was the only potential father. June 19th, 2023, petitioner went to respondent's home at his request. Respondent provided a pregnancy test for petitioner to take. There is conflicting testimony, which makes it difficult to ascertain whether the test was taken in front of respondent or with the bathroom door closed due to shy bladder. Both parties do agree that the test was positive. In the something to consider email, the court finds the language to imply that respondent, Clayton, was attempting to buy into the idea that rubbing or grinding their genitals together might have led to pregnancy. The court, however, does not find the email conclusive that Clayton believed her to be pregnant with his children, but rather an attempt to consider Owens' assertions. So he was like, well, maybe that could happen. I mean, I guess it's a possibility, but it wasn't Clayton saying, oh, yes, for sure, I believe you. In the Something to Consider email, respondent maintains the lack of intercourse would preclude him from being the father of the fetuses. The email does not deny the pregnancy test was positive. So that was something that was brought up, and they were like, well, in the email, does he tell you that that those tests weren't positive, or that that any of those tests were negative? No, he didn't say that. But by saying he didn't think the intercourse would preclude him from that. In the email, respondent suggests that the positive test was the result of petitioner's epilepsy medication. Petitioner emailed Dr. Zyman from Barrow Concussion and Brain Injury Center on June 28, 2023. The subject of the email is pregnancy and seizure med. Petitioner denies sending respondent an ultrasound video, citing instead that Greg Gillespie hacked into her email and sent the video to the respondent. Petitioner testified that July 2nd, 2023, she anonymously sought care at Planned Parenthood in Los Angeles while she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias. Respondent presumably sought records from all Mission Viejo Planned Parenthoods. Sought records all Mission Planned Parent, as that is where up until the hearing in her mind today, petitioner disclosed she sought care. Petitioner testified that she had the sonogram at Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent respondent from tracking down the records. The court was not provided those records at trial. No. She was told that she needed to hand over her discovery and disclose everything regarding this hearing. And she did not. Now, to push back a little bit, I know people aren't going to like this, but there was mention of a June 28th, a July 2nd, and a July 7th on that Planned Parenthood appointment that we know, never went to. But, so I don't know if that's something that Gingras is going to fight. But if he does, it's going to be, well, June 28th was a Wednesday, not a Sunday, so therefore Planned Parenthood was opened. So that may be something that he tries to fight, but the fact that the date has changed 3 times, it makes it uncredible. It's no matter what day, she didn't provide the records to prove anything. She had plenty of time. She decided to lie about it several times, and even at the court hearing, she still provided nothing to keep everybody from finding out the truth, which we know the truth, and those records don't exist, because why wouldn't you bring them or tell your attorney about them if they cleared your name? Petitioner testified that on July 23rd, 2023, she experienced bleeding and passed 2 small fleshy objects, smaller in size than her hand. She took pictures of this tissue and sought telehealth assistance. Petitioner testified that she texted miscarriage hotline and sought telehealth assistance. The telehealth provider told petitioner it was hard to tell if she miscarried and she should monitor the situation and seek further care as needed. Petitioner chose not to seek in-person care that would have confirmed if she had been, still was, or had miscarried. It was another chance for her to prove with somebody in person in real life about pregnancy. Because even if she had miscarried, that would have still proved that she was pregnant. We still wouldn't have known by who, but it was another chance that she would have had more documentation about there actually being babies. But there wasn't. The court finds the hard-to-tell component of the telehealth visit was due to the nature of the telehealth and the inability to provide care in the form of an exam, an HCG test, a blood test, an ultrasound, or a sonogram. She could have gotten those things to prove her case and that she is pregnant all by going to an in-person visit to a doctor. She would have all these elements, things that everybody's been looking for, had she gone to an urgent care. Heck, go back to Banner Urgent Care. Their patient portal is amazing. We would have seen it all. Instead of seeking in-person care, petitioner chose to take another HCG home pregnancy test on July 25th, 2023, which was positive. Petitioner again took an at-home pregnancy test instead of seeking care on August 1st, 2023. Petitioner testified that she made multiple appointments to see Dr. McCool. 3 of the 4 appointments were rescheduled and then canceled when the petitioner tested positive for COVID. Dr. McCool's records indicated 44 pages of records confirming, making, and canceling an appointment. Dr. McCool, what does your system record that like 3 to 4 appointments gives you 44 pages of activity? That is very interesting. Granted, she said she like submitted information and stuff or sent them things, so maybe it was that, but there was never an appointment. But 44 pages for a patient that has never been seen. Interesting. Tested McCool's records confirming it just indicated that she confirmed that she made appointments and canceled the appointments. The court was not provided the evidence for positive COVID test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room, who would be equipped to care for her high-risk pregnancy, wherein the mother has COVID, or tested positive for COVID. If you are pregnant and you end up with COVID, it can make your pregnancy harder. It can cause some preeclampsia and some other things. She might have done just an at-home COVID test like she does her P-test, but it could cause some things, and depending on when she had it or certain things, babies can get it too. So why are you not going to the doctor? Normal women don't do this behavior. Thankfully, Judge Mata knows this. Continuing on, in August 2023, the parties agreed to DNA test through Ravgen. Petitioner paid $725 to Ravgen for the test, but respondent failed to provide a sample, and petitioner canceled the test on August 18th, 2023. Very important here. The court does not find that sexual contact between the petitioner and the respondent, Owens v. Echard, resulted in pregnancy. The court finds that if the petitioner was pregnant, it is profoundly unlikely that conception occurred because of rubbing, grinding, and oral. because we are taught that's not how babies are made. During this litigation, if petitioner had maintained consistently an allegation of SA, coupled with a police report or a physical exam, the court may find differently. Evidence and testimony, however, do not support this inconsistent contention. Yeah, if she would have claimed this a long, long time ago and had some proof to back it up, that'd be another thing. We have no proof. Petitioner admitted to changing an HCG test result to reflect 31,000. I think that's supposed to be 131,000 and the 9,900 and something. She further testified that she altered the document using Adobe but not Adobe Acrobat. In late September or early October, both parties submitted samples to Ravgen for DNA testing. October 16, 2023, the petitioner's blood was drawn and the results were HCG levels of 102. Petitioners changed the results to reflect 102,000, which there's no exhibit for that. Like, I still don't think that there was an exhibit for that. And if somebody has it, please link it to me or where it is in a video that somebody has seen. Because I still think there's only the one that she doctored and sent to, like, Dave Neal and stuff. And then the original 102 one. I don't know about this 102,000 one. Petitioner testified that on October 18th, 2023, she was aware the alleged pregnancies were not viable and filed the request for pre-decree mediation in the hopes that at mediation she could tell the respondent that the pregnancy was no longer viable. Upon denial of her request, however, she did not file a motion to dismiss or make other arrangements to advise respondent of the development. So she could have still found a way to tell Clayton back in October that she was no longer pregnant. She didn't. She didn't do that. She just said, well, that's why I filed this. Okay. But it never came out, and you never thought to try to get the information to him. You're like, well, it's denied, so I guess he doesn't need to know. Upon denial of her request, however, she did not file the motion. The court finds this testimony uncredible and a misuse of judicial resources. Petitioner was not treated by Dr. McCool or Dr. Higley as testified to in her November 2nd, 2023 hearing on the injunction against harassment. Yeah, I don't think the judge likes your little minor perjury. Petitioner's alleged pregnancy was not treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist. The court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncredible. Yes. Yes, yes, yes. Because this is not how pregnant women respond. The court further finds that going to Banner for pregnancy test, but not the passage of fetal tissue, to be unreasonable and uncredible. A reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of a pregnancy. Yeah, you are willing to go there to get a test to say you are pregnant, but you are not willing to go there to get one that says you're still pregnant or you're not pregnant. You couldn't rely on them for that because you don't want that in health documents. You just take your little HCG stuff. But you can still say, well, I consulted telehealth doctors, so I still sought health care. No. This is not what reasonable and credible people do. You'll go there for a pregnancy test, but not if it is actually something that could harm you. Like, you could end up very sick along with, the babies and stuff like that, but just your own health if you were in that situation. You should go and make sure that you're okay, even if the babies aren't okay. But, there was no reason to do any of this because there were no babies. Petitioner testified that on November 14th, 2023, she sought OBGYN services from a facility called MomDoc to determine whether she was allegedly still pregnant. At that appointment, petitioner took 2 pregnancy tests that were both negative. Also, why? If we go back up a couple paragraphs here, October 18th, 2023, petitioner testified she was aware that the alleged pregnancies were not viable. And that's why she wanted the request for a pre-decree mediation. Not meditation, not medication, which I have read it as before. But October 18th, she knew the pregnancy was no longer viable. But yet, almost a month later, November 14th, she's going to MomDoc to determine if she's still pregnant. That does not make sense. You wanted to drop the paternity suit and everything and tell him that the babies were not viable and, you weren't going to be pregnant anymore. The babies weren't going to be there anymore. Let's drop the suit. But yet a month later, you're still going to find out if you're pregnant or not pregnant? Make it make sense. And you can't. And that's the judge's point on a lot of this stuff. At that appointment, petitioner took 2 pregnancy tests that were both negative. Petitioner testified that she currently weighs 91 pounds, which, God, she's so skinny right now. Her weight is just not good. She needs to put some more meat back on her bones. It's not healthy. But weighs 133 in November 2023 during the MomDoc appointment. She experienced significant swelling in her abdomen and felt pregnant. Yeah, she made sure she said felt pregnant because, Dringer says if she believed she was pregnant, she can file this suit. If Amber Heard believes that she was abused, she can file abuse allegations. I hate all this stuff. Just because somebody believes something doesn't make it real. Felt pregnant. Jesus. So, story time. Just a minute. Sorry. But there was a time, my daughter was like in 4th grade or something. She hadn't started getting monthly visits from Aunt Flo, TMI, but it makes this point of the story very important. But she was having, 4th, 5th grade, so no Aunt Flo yet, and that's about the time that girls start going through changes and stuff like that. And she was Googling symptoms, of like nausea and different things that go along with puberty. And some of those symptoms in puberty also can go with pregnancy. And so she had convinced herself on Google, and of course not yet have ever had intercourse or been essayed or anything like that in her life, which puberty and Aunt Flo visits and actually doing the deed are two huge parts of being pregnant. But she had convinced herself that she felt pregnant, like Owens. She felt pregnant in 4th or 5th grade. And I could not convince her. Like, I would tell her all this stuff and everything. Could not convince her. So I ended up taking her to the doctor and having the doctor explain to her that it's not scientifically possible and all this stuff. But this goes to say, just because you feel pregnant or you might believe you're pregnant doesn't make it true. But yeah, I have a strong-willed daughter. But yeah. Anyways, back to this motion or ruling. The court was presented with video dated September 19th, 2023 and October 9th, 2023. The petitioner sent respondent of her abdomen as evidence of pregnancy. Dr. Medchill testified that while she appeared pregnant, that alone was not conclusive of pregnancy. Which I'm glad she caught. Because I caught it, and I showed it to y'all, and my afterthoughts of the trial is that it could be that, it could be something else. And a swollen abdomen isn't, bam, you're pregnant. Petitioner denies tampering with HCG tests, but does admit to altering, fabricating ultrasounds and sonograms. She further testified that she changed the HCG numbers on 2 of the results. The court finds little, if any, difference in altering the test itself, for which she denies, and altering the results, which she did tamper with by her own admission. During petitioner's cross-examination, it became profoundly obvious that counsel for petitioner was attempting to coach her answers. Respondent's counsel identifying the issue moved between counsel and the petitioner. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. The court had to remind the petitioner twice that counsel would ask questions and she needed to answer it. At this time, petitioner pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner to no avail. At this time, petitioner became emotional and asked for a brief recess, which the court granted. Now, something that Gingras has already showed us that he may push back on is that he has the right to gesture to his client, like calming the witness or whatever he has posted on Twitter. And my opinion of that is it talks about during an objection. And that would be fine if that was the only time Gingras was signaling baseball signals to Owens. But no, he was doing it in her testimony, not during times of an objection, trying to be like, okay, calm down, like don't speak when there's an objection, just wait, because you can't say anything until the judge rules on the objection. But that was not what was happening here. So he can try to say that, but all we've got to do is say roll the tape. The court finds this interaction between counsel and petitioner diminishes the credibility and the veracity of the petitioner's responses during cross-examination. The court finds it is impossible to determine the date of any alleged miscarriage, not because it's impossible, but rather because she failed to seek even a minimal level of care for her high-risk condition. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure respondent would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted. Owens never wanted Clayton to know that, because then he'd know that she lied. Dr. Michael Medchill, MD, a retired OBGYN and prior chair at St. Joseph's Hospital, testified that pregnancy is possible without intercourse. Dr. Medchill testified that he delivered 30,000 babies during his practice and saw many patients for miscarriage. Now, a number might be between 20 and 30,000. And I know that seems like a big number, but he has been in practice for about 39, 40 years prior to retiring. And so doing the math on that, that would be about 769 babies in a year, which is about 14 to 15 babies a week. Now, is it possible? Yeah. It could be. It's about 2 babies a day, but it would have to be consistent. 14 to 15 without a doubt every single week. Unless, like, it could never be less than 14 to 15 a week. It would always have to be at least 14 to 15, and then if you had some smaller weeks, I guess you could make up for it by 20 babies in a week. But that's a lot. And you would have to do that for the entire 39 years that you have been an OBGYN, and I don't think that has happened. Now, whether that's, he's probably just rounding up a little bit and not giving the exact amount, because, you know, when you've delivered a lot of babies, it's just like, I don't know, probably this many, but I don't have a way of knowing it. But anyways, it is physically possible. It might be a little exaggerated. It probably is between 20,000 and 30,000 in a 39 to 40 year career span. But I digress. Dr. Medchill testified that he reviewed approximately 200 pages of petitioner's medical records from Barrow Neurological Institute in Phoenix that included summaries of petitioner's medications. He did not, however, review primary care or historical OBGYN records. Well, we don't have any, so that's why. Nobody could review those. Dr. Medchill testified that none of the medication records he received would cause a false positive home pregnancy test. Dr. Medchill testified that a false HCG test could be the result of epilepsy medication, anxiety medication, clonazepam, horse urine, IVF, prescribed injections, also known as trigger shots, which she could have gotten through her horses or for herself. But those are 2 things that could have come from those horses. Remember, I said the horses are her life. We come back to horses once again later on. When asked by the court, Dr. Medchill testified he did not review any Planned Parenthood records from Mission Viejo or Los Angeles facilities. Well, nobody got to review Los Angeles. Dr. Medchill testified that a home pregnancy test can detect pregnancy 11 days after conception. Dr. Medchill testified that he is 99.9% sure that the petitioner was pregnant based on the HCG test. And I just don't think you can put all medical certainty on an HCG test. Like, there's a reason that doctors don't just go by that. And that, for Dr. Medchill, was all it took. So with just that one HCG test, you don't need to do any tests for your patients, Dr. Medchill, to confirm even further? Like, that's good enough for you to say that they're pregnant and plan for a birth with your patient? No, it's not. And the fact that Dr. Medchill would even sit there and say that an HCG test was enough to prove pregnancy based on 99.9% certainty is ridiculous, especially with those levels. Because I guarantee you, he would not stop at that test result. He would do it again if one of his patients came back with a 102, because it wouldn't match up if there was a baby that he had done a sonogram on or a pregnancy test. So, yeah, I'm not buying that. The court finds Dr. Medchill's testimony that 0.1% chance that the petitioner received a false positive due to several medications she is in fact taking, possible trigger shots for HCG, and prior history of ovarian cancer to diminish his credibility, especially given that the records that the petitioner testified existed were not present to her own expert for review and consideration. So she brings up these ovarian cancers and things, which we know she doesn't have, but at one point she submitted those to people, and so she claimed it in other cases. So why didn't he look at those? And he didn't get those records to even look at. Dr. Medchill testified that a blood HCG level of 102 is proof of a non-viable pregnancy. While Dr. Medchill testified that a non-viable pregnancy is still a pregnancy, the court finds that altering the number to reflect 102,000 or 131,900 and something, which would be a viable pregnancy, to indicate she intended for the respondent to believe that she was pregnant with a viable fetus. Yeah. When you're changing records, it's not like when you change that, it was because you wanted people to believe that you were pregnant with viable babies and not trying to show the truth. Like, you had an opportunity there to come forward with the truth, but no, you still continued to lie and doctor evidence. Dr. Medchill concluded that the petitioner became pregnant on May 20th, 2023, and ended with a spontaneous abortion. Late October, early November, or possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. So, Dr. Medchill basing his evidence and his conclusion on that doctored HCG level test, the judge is saying, I can't trust these HCG tests because they were doctored. She doctored them at least once. So because you relied on doctored information, I can't trust anything. That's what happens when you lie. Everything can be thrown out because of one thing that you did. Dr. Medchill testified that women may expel tissue during a spontaneous abortion, or the pregnancy might remain in her body, ultimately being reabsorbed. Given that the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant and had seen her doctor presumably in person, the court does not accept the 24-week-old twin fetuses would be reabsorbed into the mother's body. Yeah, we can't believe that statement either, because she knew she was pregnant and that she had a growing belly, remember? So that didn't go with the original thing. She came up with this later. Like, it wasn't a part of the original plan. She had to come up with something. So we're not buying into that narrative either. The court further finds a miscarriage at that stage of the pregnancy would result in emergency medical care and corresponding death certificates of the twins. If what Dr. Mitchell testified to is true and she miscarried much sooner, negating the need for the death certificate, then petitioner perjured herself at the prior hearing. So she's like, she perjured herself by saying she was 24 weeks pregnant and seen the doctor. She lied about that Or she miscarried earlier and she was still lying. Did you miscarry now after that when you lied to the court, or did you do it prior to the court in which you still lie? All roads lead back to lying. Sooner or later, it all leads to lying. Samantha Deans, MD. Dr. Samantha Deans, MD, reviewed petitioner's records and provided her analysis of the HCG results. Additionally, she was the prior associate medical director of Planned Parenthood in Florida and Pennsylvania. She testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open Sundays, which petitioner testified she sought care July 2nd, 2023. Dr. Deans testified that the HCG does not confirm pregnancy. There must be serial HCG or an ultrasound, an examination, which were never done or never disclosed to the court. The respondent, Dr. Medchill or Dr. Deans. Dr. Deans reviewed the July 23rd, 2023 telehealth instructions that petitioner proceeded to the emergency room for additional evaluation care. The instructions were not followed, but petitioner called the abortion and miscarriage hotline, which also recommended and encouraged petitioners seek in-person medical care. Yes, both places told her, go get evaluated. Dr. Deans testified that there is no data to indicate a conception date. After reviewing the records, Dr. Dean determined that the HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of the HCG in petitioner's blood and urine, was not indicative of human gestational norms. Dr. Deans testified that the heterophiliac autoimmune response due to exposure to animals could provide or produce a positive HCG test, but the confirmation blood test would be negative. So that might not be the thing, but she brought it back to possibly the horses once again. You know, being around the animals. She puts in there, a prior history of cancer could also produce positive HCG results. Petitioner has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. And Gingras and Owens are going to be like, no, I told you those weren't my medical records. I told you that I didn't create those. Well, the forensic guy said that they came from you. So, who sent them? Who sent these things? This is what happens when you create and send in a bunch of stuff. Is you've said you had this done and you said you didn't have this done. These were your medical records with one case, but they're not with this case. And we pretty much know all of it's bullshit. But nobody can keep all your lies straight. Even when we have people coming in that are verified, other men verified that their stuff is not tampered with. There's nothing on there with that, and all that stuff came from this person. So she's going to need to explain that to the appellate court. Why we think this and why it's not right. Yeah, explain that to the appellate court. See if they believe you after you give your explanation of this. Okay, we're a little over halfway finished. I am trying to get through this as fast as I can. Familial HCG syndrome can also provide or produce a false positive HCG test. Dr. Deans testified that syndrome is very rare with only 10 known cases in the world. And then again with the horses, horse tranquilizers can create a positive HCG test. And I wonder if the reason that Judge keeps bringing up horses is because she knows that Laura has access to many things and all things in regards to horses. So those are possible explanations. We don't have any proof of it being horses, but we don't have any proof that it's not the horses either, because we have proof of nothing in this case. Respondent Clayton Echard. Respondent denies all allegations of intercourse. Respondent confirms both parties were under the influence of marijuana, but denies being high, and further denies memory loss because of the marijuana ingestion. Respondent testified that around May 22, 2023, he realized his behavior with petitioner was unprofessional, and he intended to discontinue a sexual relationship with petitioner. He testified that upon hearing this, the petitioner became very emotional. What? Once again, when has Owens ever become very emotional? I mean, Clayton's credibility here is accurate because we have proof that she becomes very emotional and has her temper tantrums in court in every hearing that she's on. Her facial expressions and her behaviors say it all. Respondent testified that he told petitioner he had submitted the offers to the seller. Respondent testified that he did not believe the petitioner was really interested in the properties. When asked if he had received any response, respondent told petitioner that he had not, but never told petitioner the reason why no response had been received, i.e. because the offers had never been submitted. Respondent made knowingly false statements to Laura about real estate purchases. And that is the only knowingly false statement that ever existed on Clayton's part. And that was prior to pregnancy allegations and prior to court hearings. This was back in May after dealing with her. Respondent testified the petitioner sent him approximately 500 text messages using 13 different phone numbers threatening to leak information to the media. Respondent testified the petitioner reached out to the son, called his family, co-workers, and prior girlfriends, accusing him of being a deadbeat for not supporting her and the twins. Respondent testified that he received a video from petitioner and continued to correspond with her over that email string, which would reasonably prompt petitioner to advise petitioner to advise she did not send the video, but she did not advise of that at the time. Yeah, she didn't say anything about that. She tried to mention it at her order of protection hearing when she was like, well, when I went to click the link, what I had saved as that link was not what was saved as that link. And so when I sent you that link, it wasn't what it was supposed to be. Like, she tries to backtrack that. And that's why Clayton, on his own, pro per, was like, but you sent me an email with a video link, correct? And she said, yes. She said it just didn't have the right video attached. So then now she's going back and saying, well, I didn't send that. I didn't send that video. I didn't send whatever. Yes, you did. Whether it was the video you intended to send or not, you still sent the link to him. So, lies. Petitioner emailed respondent, you can't say you haven't been given a voice when I have told you that I will have an abortion if we are trying things out for a few weeks and have a good reason for aborting the child. These words feel menacing because you know I like you and want to try things out with you. The email continues, you would be obliging to make the decision to date exclusively before deciding whether or not we have an abortion. I will throw these kids away and not give two shits about them if you decide to be with me. I will choose you over our babies. And that's how you know she never cared about these children. There was no children to care about. But that's why it's so easy for her to toss these fake children aside to have relationships with these guys. Because I honestly do not think that if she got pregnant in real life, that she would ever choose to abort them. I just don't think she would. And the reason she's comfortable using it right now is because they're not real. People may disagree with me on that she might actually, but I actually do not think she would. Petitioner encouraged respondent to have intercourse with her, citing she was tight, air quotes, and already pregnant. Further, emailed respondent that he had control of the outcome of the pregnancy if we date exclusively and care for each other. On June 28, 2023, she said, "If you think about it, having sex with me is the safest thing you can do at this point. I'm already pregnant, and if we choose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills. So there's no risk." There is risk because you could actually end up pregnant that time. And Clayton was like, "Nah, I'm good." Petitioner told respondent the twins were boy and girl. Petitioner provided respondent with a sonogram that was posted on YouTube 7 years ago. Petitioner admitted to doing this in her deposition. But yet, she didn't send him a video. That was Greg Gillespie who hacked into her computer, right? Like, your deposition, none of your testimony is the same where you go. Your story always changes. You sent the video, you didn't send the video. You admitted to it in your deposition, but it was hacked by Greg Gillespie now. So, you wonder why the court doesn't believe you. Petitioner sent a threatening letter to respondent indicating her intentions to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action that she initiated. Yeah, she started it all. Petitioner signed a release of records for Dr. Higley, MD at Women's Care. In a letter dated March 18, 2024, the provider advised, "We have no record of treatment for the dates of service you requested." And they have the exhibit of that they submitted. And so Higley doesn't have 44 pages of a patient he's not seen, like Dr. McCool does. Dr. McCool keeps records. Like, doctors need to learn more about record keeping if they need to or want to learn more about it. Dr. McCool might be the person you go see about that. Ask him, "Hey, how do you get 44 pages of medical information out of a patient you never saw?" Validity of petitioner's order of protection. And this is the part where Owens can be like, "See, my order of protection stands." This is the part where Clayton doesn't win 100%. But I think he won on the things that mattered. In this case, the gravamen of respondent's position is the petitioner has fabricated her pregnancy, a condition which cannot have resulted from the parties' interactions because, according to the respondent, they never had intercourse. But he does admit that the pair engaged in oral. Respondent seeks to have the protection order invalidated based on the alleged fabrication, while petitioner essentially argues that even if she was never pregnant, the rendezvous between the two and respondent's subsequent harassing online conduct are sufficient to stain the order regardless. There is a predicated issue that should be addressed, which goes to the court's authority to reconsider the protective order at all, but simply extant appellate authority, namely Vera v. Rogers, a 2020 2018 case in Arizona, and like cases precludes reconsideration here. In Vera, the mother applied for a protective order in Phoenix Municipal Court, but it was eventually transferred to the Superior Court after father petitioned to establish legal decision-making authority, parenting time, and child support. After a contested hearing, the commissioner handling the order of protection affirmed it in its entirety. Father then filed a special action asking the Court of Appeals to order the family court to amend the order of protection to align it with the temporary parenting time orders it had made in a separate case. The Court of Appeals accepted the special actions, finding it raised a purely legal issue of first impression that is of statewide importance, to wit, the interplay between the procedural rules and the statutes governing protective orders and family law proceedings. The Court of Appeals first recognized that the Superior Court, pursuant to Arizona Rules Family Law Procedure, has the authority to hold a joint hearing to concurrently consider both actions so that it may harmonize the orders. But having said that, the court noted that the Superior Court's authority to modify an order of protection only exists pursuant to the statutes and rules controlling protective orders, and those statutes and rules prevent the relief father sought in the Vera. Because another Superior Court officer had already affirmed the contested order of protection, indeed the court stated that once a contested hearing has been held, an affirmed order of protection may be amended or dismissed only in two ways: by request of the party protected by the order, or by an appeal. So I don't know if Clayton tried to appeal it or not. Because mother had not requested amendment and the father did not appeal from what amounted to the final judgment, he could not obtain relief, and family court had no power to amend the protective order. Put another way, a Superior Court judicial officer is not engaged in a horizontal appellate review of another judicial officer's decision to affirm an order of protection. See Davis v. Davis, which is a appellate court in 1999 in Arizona, holding that a Superior Court judge has no jurisdiction to review or change the judgment of another Superior Court judge when the judgment has become final. Just like in Vera, absent a move by petitioner to modify or dismiss the protective order, respondent's sole remedy was to appeal. Yeah, so if Owens doesn't want to modify or dismiss the protective order, Clayton's only remedy is to appeal it. And if Clayton didn't appeal it in a timely manner, then, it's final and there's nothing that can be done. And that's why everybody should have lawyers. I don't know if he did at this point. I don't know that he did. Although Vera did not involve fraud, this court was unable to identify any cases collaterally changing a final protective order judgment on Rule 85 grounds in a separate family court proceeding, nor any authority suggested that Vera's exclusive roadmap, which is rooted in Arizona law, for amending or dismissing a final order of protection judgment is subject to an exception based on Rule 85 review. This court's power to invalidate the order is foreclosed by Vera. So she's saying she looked at all this stuff. It may have been one of the biggest things and reasonings why she wanted to take this under advisement, if she hadn't already been looking at this stuff prior to, so that she could maybe try to find some case law that would back up reversing this, because maybe she doesn't like that this woman who fabricated all this stuff and has lied has essentially tainted the reputation of Clayton and his record, because he has a protective order on him, and so that's on his record. And she probably doesn't feel like he needs it or it's warranted. And sometimes Owens wants to talk, it's not fair. But what's not fair is that you still get away with tainting somebody's reputation when you shouldn't have been allowed to. And it should be able to be reversed. Even if Farah did not foreclose this court's review, respondent cannot prevail here, despite what appears to be a case of serial fabrications. Serial fabrications. Here and elsewhere by petitioner. Under ARS 133601A6, the parties admittedly had a relationship that was previously romantic or sexual, however fleeting it might have been. Petitioner thus had a statutory avenue to seek a protection order, which I have said, and Gingras has argued that even if you take out the pregnancy, because they had that romantic interaction or dating relationship, she could seek an order of protection. She could. Like, nobody's saying people can't go seek them, but it doesn't mean that the outcome was right or it should have been granted. But she had the right to file it. Regardless of whether she fabricated pregnancies. Moreover, Commissioner Duty did not issue the order based solely on, even primarily on, the fact of petitioner's pregnancy. So she just threw Gingras a bone and said, you're right about this, it wasn't based solely on the fact of the pregnancy. Indeed, his initial order required that respondent not contact petitioner or communicate or post untrue or harassing comments regarding plaintiff online. Included, but not limited to, social media, and shall not cause others to do the same. Clayton didn't cause any of us to do it. Owens' behavior caused a lot of us to speak out, not Clayton. He never told us to, or anything like that. And he most definitely was not out there sharing untrue comments. Nothing about what he said has been untrue, as far as the pregnancy stuff goes in this case, in my opinion. Moreover, petitioner's initial petition referenced a myriad of communications respondent made to her that could be deemed threatening per the statutory guidelines, and appears to have prompted Commissioner Duty to confirm the order after the hearing. Thus, even if petitioner's broader pregnancy allegations are proven untrue, one aspect of the court's order indicated that it found respondent had engaged in harassing conduct. So, even on the merits, there is no cause to invalidate the final judgment. Vera v. Rogers forecloses not only reviewing the orders in principle, but also prevents tinkering at the margins as well if the Superior Court cannot engage in horizontal appellate review of another judicial officer's decision to affirm an order of protection. 246 Arizona at 36, there is no way that the court can otherwise review portions of those decisions piecemeal either. The parties' remedies as to both decisions were to appeal and have the appellate court review the entirety of those decisions, and she has seen nothing on that. She didn't say that, but she hasn't seen anything like that. That was the remedy, and it wasn't sought. Both had hearings as to their respective orders, and under Arizona rules, an order of protection, an injunction against harassment, or an injunction against workplace harassment that is entered, affirmed, modified, or quashed after a hearing at which both parties had the opportunity to appear is appealable. They could have appealed these things. I don't know if he still can. Now she goes into the sanctions. Arizona Rules of Family Law Procedure 26 provides that by signing a pleading, motion, or other document, the attorney or parties certifies to the best of the person's knowledge, information, and belief formed after reasonable inquiry, 1, it is not being presented for any improper purposes such as to harass. So you cannot file lawsuits to harass somebody. 2, the claims, defenses, and other legal contentions are warranted by existing law. You have to have law. 3, factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after reasonable opportunity for further investigation or discovery. So you should have evidence to back up your claims that you are filing. If you don't have that evidence at the time of your filing, but it can be discovered in the discovery phase while they're investigating and you're supposed to be handing over things and everything like that, then you'd be okay too. Meanwhile, Rule 26C provides that if a pleading, motion, or other document is signed in a violation of this rule, the court, on a motion or its own, may impose on the person who signed it, a represented party, or both, an appropriate sanction which may include an order to pay the other party or parties the amount of reasonable expenses incurred because of that filing of the document, including a reasonable attorney fee. Emphasis added. So she doesn't need somebody to file or not file or withdraw or not withdraw a Rule 26 sanction, because the court can use Rule 26 on its own without any filings of the motions. In this case, respondent filed a motion for sanctions pursuant to Rule 26 on January 3, 2024, arguing that petitioner filed the underlying action for improper purpose without medical evidence to support her claim that she was pregnant and/or she was pregnant by respondent. However, after significant motion practice between the parties, attorneys, respondent filed a motion to withdraw motions for sanctions pursuant to Rule 26 on April 3, 2024, while retaining his other claims under ARS 25-324, 25-415, 25-809. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion? I don't know. Can she? Let's find out. As already noted above, Rule 26 expressly provides that the court can sanction a party for a violation on its own. The court was unable to locate any decisions pertaining to whether the withdrawal of a party's Rule 26 sanctioned motion precludes a sua sponte court award. But as a matter of plain meaning and strict interpretation, it would seem not to matter whether a party ever files a motion or whether the party does file a motion and then withdraws it. A court may still award the sanction it deems appropriate, based on the conduct it deems to violate the rule. Still based on the conduct it deems to violate the rule. Indeed, if per Rule 26C, the court can at any time award sanctions of its own accord and on its own findings, absent invitation, withdrawal of the party's motion to do so would not seem to violate or in any way affect the power as a matter of plain logic. So, for instance, if the court were to here find the petitioner fabricated her pregnancies to provide leverage against respondent in order to secure a long-term relationship with him and all of its attendant benefits, like just for a hypothetical here, if Owens fabricated all of her pregnancy shit to get a long-term relationship, we're just using a hypothetical here. I'm not saying that's what she did. But, just for an example, if somebody had done this before, Rule 26 would appear without doubt to provide an authority to call, order her to pay respondent his reasonable expenses, including a reasonable attorney fee, regardless of any prior filings by the parties. That is because that fabrication, if adjudicated as such, would have been the predicate for her initial petition and many, indeed all, of the motions that came after it. Yes, because if this pregnancy was completely fabricated, that any time she submitted a motion stating that she was pregnant and drew this further and further out, made there more expenses, medical witnesses, all this stuff, because she cannot admit that there was no pregnancy and she faked it all. Every time she puts in her motions and continues to fabricate this lie of pregnancy, she can be sanctioned for those things, because it didn't just stop when she stopped being pregnant. She continued to carry on with her fabrication of her being pregnant at all. And there's no proof that she was pregnant. So therefore, every time she says there is, it's her continuing to lie and fabricate things. Which means we still have to continue this case. The only way to save people money and not award sanctions would be for her to have not filed this and ever alleged this stuff, or for her to come out and admit that it was all fabricated. She didn't do any of that, so here we are. Although there is a dearth of case law on this issue, after rules confirm that the family court has the authority to award sanction on its own, Rule 76.2A1, for instance, provides that in a prejudgment or post-judgment proceeding, the court, upon motion or its own initiative, may impose sanctions if a party or attorney, 1, fails to obey scheduling or pretrial order. Well, she didn't obey pretrial orders. 2, fails to appear at a resolution management conference, a scheduling conference, an evidentiary hearing, a trial, and other scheduled hearings. 3, is substantially unprepared to participate in a conference, hearing, or trial. 4, fails to participate in good faith, which nothing she participated in this was in good faith, in a conference, hearing, or trial, or in preparing a resolution statement, scheduling statement, or pretrial statement. Emphasis added. Yes, emphasis added. We're gonna add emphasis to things on this channel. That's just gonna be a thing for us. And the remedies available include, in addition to substantive sanctions, ordering the party at fault to pay reasonable expenses, including attorney fees, an assessment to the clerk, or both, caused by noncompliance with the court order. She did not comply with court orders multiple times. See Rules 76.2. See also Hamby v. Hamby, which is an appellate in Arizona court from August 13, 2020, confirming power of the court to award sanctions on its own initiative under Rule 76. Rule 71 provides for a similar power in the settlement and ADR context. Additionally, as it is evident from their near textual identicality and per the Arizona Family Law Rules Handbook, Rule 26 is based on Arizona Rules of Civil Procedure 11. 3 comparisons with civil rules: 13 Arizona Practice of Family Law Rules Handbook, Rule 26, and Rule 11 also provides that in the event of a violation, the court, on a motion or on its own, may impose on the person who signed it, a represented party, or both, an appropriate sanction. And in Rule 11 context, the Court of Appeals has concluded that a trial court may impose sanctions even after a complainant has been dismissed for lack of prosecution. See Britt v. Stephan, 220 Arizona 265. This lends credence to the idea that the family court's inherent authority to award sanctions under Rule 26 should not be read to limited by the course of the case or by the litigation strategy pursued by the parties. The power is there by rule and can be used by the court when necessary and appropriate. So Gingrich, she says she doesn't need your legalities and knowledge on Rule 26 sanctions because she knows what she can do with those rules. She probably wanted to use your motions on Rule 26 to wipe her butt with. It became toilet paper. She's like, what is this nonsense? And he talked about it for so many motions. One, not fully Gingrich's fault because there was a clerical error and it wasn't entered, so that could have saved some paper and some time. Non-paternity. ARS 25-814A2 provides a man is presumed to be the father of a child if genetic testing affirms at least 95% probability of paternity. ARS 25-814C provides a man is presumed to be the father based on DNA testing that may only be rebutted by clear and convincing evidence. Based on a lack of confirmed pregnancy and repetitive Rabgen results of little to no fetal DNA, because we've got 2, the court cannot establish that petitioner was pregnant. She cannot say that she was pregnant because the paternity tests that there was little to no fetal DNA in there. The court cannot establish paternity of a non-confirmed pregnancy lacking DNA evidence despite testing twice. So there should have been, and at least, you tested twice, so maybe one messes up, but 2 came back that there was little to no fetal DNA. Here, 2 test results of little to no fetal DNA fall woefully short of the 95% required to meet the burden of clear and convincing evidence that respondent was the father of petitioner's alleged pregnancy. So when you don't have any, or you have very little fetal DNA in you, there is no percentage that they can attach to paternity or pregnancy at that matter, let alone boy and girl twins if we can't even find fetal DNA for there to be boys and girls. So, no, Clayton is not the father, as Maury would say. Attorney's fees and costs. Clayton Echard has requested an award of attorney's fees and cost. An award of attorney fees and cost is governed by ARS 25-324. ARS 25-324 provides as follows. A. The court, from time to time, after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings, may order a party to pay a reasonable amount of the other party for the costs and expenses of maintaining or defending any proceeding under this chapter or Chapter 4, Article 1 of this title. On request of a party or another court of competent jurisdiction, the court shall make specific findings concerning the positions of any award of fees and expenses that are based on consideration of financial resources and that are based on consideration of reasonableness of positions. The court may make these findings before, during, before, during, or after the assurance of fee award. B. If the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable costs and attorney's fees to the other party. So has Clayton met these burdens? Number 1, the petition was not filed in good faith. Ding, 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 ding. Clayton meets that criteria because Laura did not file this in good faith. 2, the petition was not grounded in fact or based on law. Ding, 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 ding. There was no fact or law to show that Owens was ever pregnant and that he was the father. 3, the petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Ding, 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 ding. She used it to harass and cause unnecessary delay and increased cost of litigation to the other party because she could not just come out and tell the truth. She still, to the day of the court hearing, cannot tell the truth. There's still evidence out there. There's not evidence out there, but she claims there's evidence out there that will show everybody that she was pregnant. But she didn't bring that to court. C, for the purpose of this section, costs and expenses may include attorney's fees, deposition costs, and other reasonableness expenses as the court finds necessary to the full and proper presentation of the action, including any appeal. D, the court may order all amounts paid directly to the attorney, who may enforce the order in the attorney's name with the same force and effect and the same manner as if the order had been made on behalf of any party to the action. The court finds. Here we go, guys. Here's our findings and our orders. Yay! The part we've been waiting for. The court finds there is no substantial disparity of financial resources between the parties. Petitioner did not provide an AFI, but testified she and her mother collectively earned $200,000 a year. Respondent filed an AFI on May 15, 2024, citing monthly income of $12,000 and an annual income of $144,000. The court further finds that petitioner acted unreasonable in the litigation. Yep. Petitioner acted unreasonable in the litigation. No matter how many times Gingras says she was not unreasonable, she has been unreasonable this entire time. Specifically, petitioner acted unreasonable when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, physical examination, and in conjunction with a belief she passed tissue on July 2023. The court finds the underlying petition premature at best, at worst, however, fraudulently, and made to incite communication, a relationship, or both with the respondent. The court further finds that filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was, in fact, to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. She can't make up her mind what it was about. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursement for those costs. So he is entitled to fees from prior to having an attorney. The court finds the petitioner repeatedly failed to comply with Rule 49, even on order of this court. She did not obey the court's orders. further compounded by the fact that on the day of the trial she testified that she anonymously sought care at Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointments, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged she altered HCG test and an ultrasound and sonogram. So, because he's having to find these records, which cost money, and that he is trying to dispute and find people to dispute and things, have a defense for these altered HCG tests and ultrasounds and sonograms, that costs him money. To sit here and have somebody say, yeah, no, those aren't real. To fight this case on all of those lies, it cost him money. The court further finds that the provisions of ARS 25324B do apply because the petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for improper purpose, such as to harass the other party, to cause an unnecessarily delay, or to increase the cost of litigation to the other party. Every time she continued with her lie, she was causing unnecessary delay and costing everybody money. Here, the court finds petitioner provided false testimony as to the viability of the pregnancy in all three cases. Once again, judge does not believe her. And there are three cases tied into Clayton's. There's the injunction against harassment, the order of protection, and then this, that is the establishing paternity and child support and parenting plan and things like that. So there are three cases of Clayton's addressed in the procedural history. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. So the judge said, you threatened him. You tried to intimidate him. The court further finds that Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25415. It is therefore ordered granting Clayton Echard's request for attorney's fees and costs associated with this case. It is further ordered denying Clayton Echard's request for attorney's fees and costs associated with the order of protection and an injunction against harassment hearings referencing the analysis above. So because she found that she couldn't overturn that, she can't do anything about the costs of those. It is further ordered that Owens shall pay Echard reasonable attorney fees and costs. Not later than January 8, 2024, Echard and his counsel shall submit all necessary and appropriate documentation to support an application for award of attorney's fees and costs, including a China doll affidavit and form of proposed order. Woodnick, you finally get your China doll affidavit that you have been wanting, and you finally get these attorney's fees and costs. All your hard work is paying off. And then it says, by no later than January 29th, 2024, Laura Owens shall file any written objection and a form of proposed order. If Echard's counsel fails to submit the documentation by July 8th, no fees or costs will be awarded. I don't think that they're going to miss this deadline. They have probably got all this ready to send in. The court shall determine the award and enter a judgment upon review, the affidavit, as well as any objections. So she's going to review Echard's motions, or not motions, but she's going to review his attorney's fees and things and costs. He's going to look at Owens' objections and stuff, and then she will issue her ruling as far as what the financial part is going to be. Additional orders. It is further ordered granting respondent petition for non-paternity. It is further ordered the court having determination that Laura Owens has filed pattern of similar, if not identical, behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for review. Laura Owens' actions pursuant to 2702 and ARS 132809. We will take a look at those in a separate video going over those charges, like we've reviewed other charges that could possibly happen with her. Accordingly, the Maricopa County Attorney's Office will be endorsed on this order. So they will be getting a copy of this order. And it's going to say all the things that you have done. The court must decide the amount of attorney's fees and costs to be awarded, but finds there is no just reason to delay making it a final order. So this is the final order. It is therefore ordered pursuant to Rule 78B, Arizona Rules of Family Law Procedure, that this is a final judgment, and it shall be entered by the clerk. The time for appeal begins upon entry of this judgment by clerk. For information on appeals, see Rule 8 and Arizona Rules of Civil Appellate Procedure. It is further ordered denying any affirmative relief sought before the date of this order. Order that it is not expressly granted above. Done in open court on 6/17/2024. And signed by the Honorable Judge Matta. So that is Judge Matta's order on Owens v. Echard. If we get to see the financial awards and documents come down about that, we will cover it. But let me know what you think. I think it was good enough for Clayton. It still sucks that she can still taint his name, even on fabrications, just because an appeal wasn't done. But sometimes it just happens like that. It's not fair, and it's the fact that it's not fair to victims like Clayton and Maraschini and Gillespie. Owens is not the victim here, even though she wants to claim victimhood and she wants to claim that she's not been treated fair when she has been given over a year to provide everything that she needs to provide. She has been given over a year to come clean, and she hasn't. So ending with our quote of the day: when justice is done, it brings joy to the righteous, but terror to the evil doers. That is a Bible quote from Proverbs 21:15. So everybody on the side of justice here is joyful and so happy that justice was done in this case, because you never know. But Owens is probably terrorizing herself, probably terrorizing her attorney right now, and is probably freaking out. having an emotional breakdown. Because this is now a court order, and this is public access to anybody. People can look this up and see this is the kind of stuff she pulls. If you like this video, please hit the like button, subscribe. We are monetized, so we do have memberships, and we've got the super chats and super thanks on just uploaded videos. Thank you for hanging in with me. I know this was a long one because I am under the weather, so it was a little slower than normal, I think. But I hope the rest of you have a good night, good morning, good afternoon, whatever it is when you are watching this, and I will see y'all next time. Bye.